Finally ready. Mr. Trush, who have we got here first?
We have Mr. Ski.
Okay, that's case number 256845. If I get counsel, put your appearances on.
Thank you, Your Honor. Richard Trush, bringing on behalf of Mr. Ski.
Okay, Mr. Trush, can you tell me the status of this file this morning?
Yes, Your Honor. So to cut to the chase, I'm going to be asking the court to consider. Well, I'm going to propose to the court two different ways to proceed. The prosecutor and I are still in negotiations. We actually had some pretty productive discussions this week about this file. There's a few different paths that we're kind of looking at in terms of potentially resolving it. The case presents some interesting issues. And I say that because having done this for quite a while at this point, even though probably the least experienced in the room, cases that actually present unique issues are fairly rare. So I would suggest to the court, if we could have another status conference, I think we likely would be able to get something done by then. If the court wanted to get it in the trial queue and give us a final status conference again, I tend to think that we probably won't need a trial on it. I think we're likely going to have a resolution, but I could understand if the court was saying, because I think we've been up in circuit court for 2 or 3 months on this one. So if we needed to get it in the trial queue, I think we could.
Well, I mean, can you kind of tell me what the unique issues are here or what?
Well, so we have what I would say several pieces that are present that may be indicative of involuntary intoxication.
Oh.
We're looking at that with some other things. And again, I don't know that it's necessarily a perfect defense for us. The prosecutor and I discussed potentially sobriety court as an option in regards to this. We've talked about some other things as well. Another issue that's sort of prevalent in this, the dosage level of the primary substance in its system. I have a doctor indicating it's below the therapeutic range, which is consistent with some other things that we have. So just some interesting issues going on. Again, frankly, I think if we can put a package together around the sobriety court, I suspect that that's going to resolve it.
Okay, and how much of an adjournment would you be requesting?
So I would suggest for the court 30 days. I think if we did 30 days, we'd come back at least knowing if we're going to be able to get there. We may not have a firm answer on the sobriety court yet, but at least we'd be able to tell the court, hey, we have a resolution. We're just, buffing out the rough spots.
Okay. Mr. Rolla, do you have any objection to that adjournment?
I do not, Judge. And to give Mr. Trush some additional information to talk to his client about, I did some further checking after I spoke with him yesterday. It would be one, not only do we want to keep the option of the sobriety court open, but perhaps after speaking with the prosecutor who originally issued this charge, it may be one that we might even be agreeable to have it reduced to a second unsuccessful completion of the sobriety court, which would be obviously beneficial to.
Sir, have you had an opportunity to speak with your attorney about this delay?
Yes, sir.
Do you have any objection to that? All right, so the court will set this for a status conference plea hearing in about 30 days, and we'll go forward at that time. Just make sure that you stay in touch with Mr. Trush between now.
Judge, this is the second adjournment. The last one was for 60 days. People don't want to have this adjournment further time.
Right, and I think we all recognize that if we don't have a resolution at the next hearing, we'll get it on the trial calendar and go forward.
Thank you, Your Honor.
Okay, thank you. And Mr. Trush, Mr. Thompson, hearing by Zoom, by prior approval, I have him connected right now. Sir, is your name Jason Thompson?
Yes, it is.
Okay, we'll go on the record in People versus Jason Thompson, file number 6870. The record should reflect Mr. Thompson is appearing today by Zoom by prior approval of the court. If I could have counsel put your appearances on.
The record, Your Honor, I call the people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Thompson.
Mr. Church, can you tell me the status of this file today?
Your Honor, this is our first status conference up here in circuit court. I've been in discussions with Mr. Thompson. Ultimately, there are some things we're still trying to put together for the prosecutor, so I would ask the court to consider an adjournment.
How much of an adjournment are you asking?
I think 30 days would probably be sufficient for us to get that input.
All right, Mr. Rolla, do the people have any objection to that?
We don't, Judge, and there is a plea offer that's been extended as well in regards to pleas to count 1 and 3 for dismissal of count 2. So I don't have any problem with the defense taking some time to discuss that.
All right, Mr. Thompson, have you talked to your attorney, Mr. Trush, about adjourning this case?
Yes.
Do you have any objection to that?
No, sir.
Okay, so I'm going to set this for a status conference and plea hearing in about 30 days. Mr. Thompson, it's important that you stay in touch with your attorney between now and then.
Okay.
At that next hearing, I'm going to be asking you to make a final decision about whether you want to accept any plea offer in this case. So it's important between now and then that you talk to your attorney and that you be ready with that decision at the next hearing, okay?
Yes.
All right. Mr. Rolla, anything else we need to address?
No, Judge, thank you.
Mr. Trush.
No.
Mr. Thompson, do you have any questions about how we're going to proceed with your case?
No, sir.
Okay, thank you. You're free to disconnect at this time.
All right. Thank you.
And Mr. Thompson, the next case is Mr. Reynold. Have you seen him yet today?
I have not, but I believe he will be logging in via Zoom.
Oh, is that going to be a Zoom one? Okay.
Well, I mean, I think it was noticed for in person, but he disagreed with me.
Let me see. Let me see that file.
And
Someone just went to the restroom. Someone just, a gentleman just walked up the stairs, but they don't recognize him as the restrooms. It could be.
that might be Mr. Gallagher.
Let's just take a short recess. We're a little bit ahead of schedule and we'll come back on the record.
Judge, before we go to recess, I can speak that we have a new person appearing in court today on behalf of the department.
Okay, we're on the record in People versus Reynold, case number 236505. If I could have counsel put your appearances on the record.
For the record, Your Honor, I call that people.
Thank you, Your Honor. Richard Kirsch, appearing on behalf of Mr. Reynold.
Okay, this hearing was set for 9:15. Yeah, 9:15. It's 9:20. Mr. Reynold, that's not present here in the courtroom today. I do have a Google device. It doesn't indicate a name in the Zoom waiting room. This hearing was noticed up as an in-person hearing. It's on the docket as an in-person hearing. It's my practice not to allow individuals to appear remotely for hearings that are scheduled in person unless they have prior approval by the court. Again, it's my view that litigants don't. Mr. Reynold can't just decide that he doesn't want to come to court today and appear by Zoom on his own. So if that is him, he does not have prior approval to appear by Zoom, and he had noticed that it was in person. I'm just making my record here. So in my view, he's waived his appearance here in court today by not appearing in person. I think we can still go forward with your motion, Mr. Trush. I did have a chance to read that as well as the prosecutor's response. Is there anything that you wanted to state for the record in support of the motion today?
No, Your Honor, I would rely on my written brief here. I outlined the two issues that I think are important. The first being, in order to extend, I think there has to be either a rehabilitative goal or an articulable risk to the community. I don't think either of those are present here. Additionally, I think there is some evidence that can be read from other portions of the statute that suggests that extension for payment of fines and costs is no longer appropriate. Specifically, I would point to the provisions that say you can't deny early release to somebody who, for just non-payment. Granted, there is a good faith portion of that, but still, I think all of those things read together make it clear that this is not a good reason to continue to extend someone.
Thank you, Mr. Rowland.
Judge, as I indicated in my response, the provision that defense is relying on actually deals with, you can't do that if you're doing it as an objection to early release. This is not an early release situation. The defendant clearly was on probation at the time the court issued an order to extend his probation. He then committed a criminal act, driving a license suspended, and that's the basis for the PV. That's why I cited the cases of Andrew remarks in mind, as well as the applicable statute, which is MCL 771.21. That's which allows the court for a person to be placed on probation for up to 3 years, as the court's well aware. In this case, Mr. Rowland, actually over the prosecution's objection, was given probation in term of only 1 year, but the court then, before the expiration of that 1 year, extended his probation, and then we had the violation. Quite frankly, the argument made by defense counsel is contrary to statute, contrary to law, and even if the provision of the statute were interpreted as requested by the defense, there's also an additional condition under subsection 4 of MCL 771.2, which requires that the court can't deny an early discharge as long as the probationer has made a good faith effort to make payments. This record is completely absent of any evidence that that had taken place, even though that's really not the evidence. For all those reasons, we should deny it.
Thank you. Mr. Church, anything that you wanted to say in response?
Just to respond briefly to the good faith effort argument, I think that really gets to the crux of what I'm trying to get at here, which is, I think to extend him, there's analysis the court should go through. A part of that would be, I think, is there good faith effort or not? Is there a rehabilitative goal that's furthered or not? Is there a risk to the community or not? And again, I attached to mine the petition, I think, from the probation department to the court, which is really just devoid of all of that. All it says is, that he still needs to pay his fines and costs, basically. And again, I think that there's more than that. And again, I would probably feel differently if it was a situation where we're talking about as a restitution amount to a victim, right? That might be something where you could say, hey, there's a rehabilitative side to this, or there's a risk side to this. Just fines for the court, I don't think meet that criteria. Thank you.
Okay. I think the defendant raises a number of different issues here. Number one, the extension of probation for the payment of fines and costs. I agree that generally those petitions, when they're submitted by the probation agent, are relatively brief, as the one was in this case. I agree with defendant's position under the statute that in order to extend probation, the court has to find either that it's necessary for the pursuit of the rehabilitative goals, which is the one that applies in this case. Clearly, the non-payment of fines and costs doesn't really relate at all to public safety or the safety of the victim. It's my view that because when a court imposes fines and costs at the time of sentencing along with probation, that those fines and costs by statute must be made a condition of probation. So in my view, for an individual to successfully complete probation, they have to comply with all the conditions, one of which is the payment of fines and costs. There are some exceptions to that. The defendant can petition the court under the statute to waive some or all of the fines and costs based on financial hardship, and there's an analysis that the court would have to go through to make that determination. So even if they haven't paid that, if it's a condition of probation that relates only to payment of fines and costs, they can still get out from underneath that by petitioning the court, having a hearing where the court would conduct that ability to pay analysis and good faith to comply analysis. That didn't happen in this case. The other thing I think that the defendant could do is when he gets notice that his probation is being extended for non-payment of fines and costs, is to challenge that extension of probation at the time and say, look, I've made a good faith effort, or I don't have the ability to pay, and my probation should not be extended for this reason only. The defendant didn't do that either. In terms of the extension in and of itself, again, because I view payment of fines and costs as a condition of probation and necessary to the successful completion of probation, and because the payment of fines and costs is part of the punitive sanction associated with sentencing and being convicted of a crime, I do think that there is a rehabilitative goal to requiring somebody to make those payments. And so I do think that extensions are appropriate as a rehabilitative goal generally for non-payment or failure to pay fines and costs. Again, there are ways for defendants to get out from underneath that by petitioning the court, by challenging the extension, and then showing that they don't have the ability to pay, or that they've made a good faith effort to pay and just couldn't do it. So I think it was appropriately extended in this case in pursuit of a real rehabilitative goal. The defendant did not challenge either the extension or the payment of fines and costs, or petition the court to have them reduced or waived based on its financial condition at the time it was extended or at any other time. So while I think all of those would have been good arguments for the defendant to raise at the time of the extension, here we are now. The defendant didn't challenge the extension. The court signed it. His probation was extended. And now it's only when he's in trouble for something else that isn't related to payment, fines, and costs, which I think if that were the case, again, the defendant would have a good argument right now that he shouldn't be violated because of good faith or inability to pay. But when he gets violated for allegedly committing another criminal offense, now he wants to retroactively challenge the extension. And I think that's the real problem here. And ultimately the reason why I'm denying the relief that the defendant's requesting is I don't think you can not challenge the extension, and then when you get in trouble later, try to retroactively attack that extension. I don't find that there's any basis either in the statute or case law that would allow the defendant to do that. So for those reasons, the court will deny the motion, and Mr. Trush, I would ask that you prepare an order reflecting that ruling. And then I believe we have a hearing set for September 4th on violation. So we'll just proceed as scheduled on that. Anything further, Mr. Church? In this case?
Just looking to see if I have that notice yet. And that answered my question.
Okay.
So nothing further, thank you.
All right, thank you. And have you seen Mr. Gallagher? I have People versus Anthony Gallagher at 9:15.
Oh, I thought you said you saw him, and I was like,
No, I said, did you see
Oh.
Mr. Gallagher? Sorry. To enunciate more properly.
I'm sorry, did the court call the case?
Yes, that's file number 256872, People versus Anthony Gallagher.
For the record, John, my phone.
Thank you, Your Honor. Richard Trishberry on behalf of Mr. Gallagher. Your Honor, this is a situation where I have not had contact with Mr. Gallagher since the bind over. The charges were amended at the time of the bind over. The prosecutor amended the charges. We do have an offer in place, and frankly, it's consistent with what Mr. Gallagher and I discussed. And I suspect he'll take advantage of it. But again, I have not had any contact with him. I've been trying to get hold of him for a couple of weeks with no response from the number he's given me.
Thank you, Mr. Rolla.
The last information we had with Mr. Gallagher being present was on July 3rd when he got arraigned. I don't know where he is at this point in time. There is a plea offer. I will confirm that. And Mr. Truce indicated he believes his client is going to accept it. I do not know when he's here. I do know, however, it's now 9:32. It's like a 9:15 hearing, and Mr. Gallagher is not present.
The court will set this for a show cause and status conference in 30 days. Give Mr. Gallagher an additional opportunity to appear. If he fails to appear at that next hearing, the court will issue a bench warrant for his arrest and revoke his bond. And Mr. Truce, I'll just ask that you continue to try and contact him.
Absolutely, Your Honor. Thank you.
And our sentencing in People versus Jefferson was adjourned based on defense counsel emergency with defense counsel, so that's off the docket. Which means our next hearing is not now until this afternoon at 1:30. The court will be in recess until that.